So, a lawsuit between two content creators over similar aesthetics just got dropped. And this case was being closely watched because it could have changed how we think about copyright in the content creation space. Just in case you don't know, hi, I'm Michelle, and I am a small business attorney helping business owners understand legal without the confusion. So, let's break down what happened and what it means for protecting your own content. So, the plaintiff, Sydney Nicole Gifford, filed a lawsuit against Alyssa Shield, and the plaintiff claimed that the defendant copied her neutral, beige, and cream aesthetic, but this just wasn't about colors. Gifford had also argued that this was her distinctive brand identity that Shield, the defendant, systematically replicated. And so this lawsuit included 8 different claims, including copyright infringement, trade dress infringement, and misappropriation. And the damages had the plaintiff won could have reached millions. So the plaintiff claimed that the defendant replicated her entire brand identity and online persona, not just like the similar neutral color palettes, but also comparable camera angles and fonts, the same Amazon product styled in similar ways, and claims extended to copying physical appearance, including specific traits like a flower tattoo. And she also alleged that she was copying her relatable tone in product promotion. So the case was dismissed this week with the defendant paying nothing. And after mediation, the plaintiff requested dismissal with prejudice. And because of that, no legal precedent was set since it didn't go to trial. So copyright protects the specific way you express an idea. It doesn't protect general concepts, styles, or aesthetics. And color palettes alone are also not copyrightable. So for something to be copyrightable, it must be your original creation. There has to be some type of creativity, and common elements used by many people do not qualify. So initially, some of the claims were dismissed. The magistrate recommended dismissing the plaintiff's tortious interference, unfair competition, and unjust enrichment claims right away. But the core claims still survive. So they allowed her to still claim copyright infringement, trade dress infringement, DMCA violations, as well as misappropriation of likeness. And that's significant because it means that the judge thought these claims had merit enough to go forward. And the court noted that this appeared to be first of its kind case, but surviving a motion to dismiss is different from actually winning at trial. It just means that the claims weren't obviously without merit. This case may have been challenging for copyright claims. The general aesthetic similarities aren't enough to say that it was copying, and she would have had to show substantial similarity in specific expression. As far as the trade dress claims, she would have had to prove that the look and feel is distinctive. She would have had to prove consumer confusion about the source, and that is difficult when many creators use similar aesthetic. Now, copyright protects the specific way you express an idea, not the idea itself. So your actual photos, videos, and written content are protected. However, general concepts and styles usually aren't. But when someone systematically copies your specific expressions, that's a different story. So again, your original creation has to have some creativity. And so in the plaintiff's case, she wasn't just claiming ownership of neutral colors. She was pointing to specific copied elements of her brand expression. And then with regard to trade dress, it protects the overall look and feel of your brand when it's truly distinctive. And looking at the evidence in this case, Gifford may have had a very strong argument that her specific combination of elements created a recognizable brand identity. And just a reminder, her core claims survived the motion to dismiss. A judge looked at the evidence and said that these claims were worth pursuing at trial. Now, just because the plaintiff's claim survived a motion to dismiss, that doesn't mean they would have won. That just means that she did have some claims that she could have argued. And both sides are claiming a victory here. The defendant's team says she prevailed and paid nothing, while the plaintiff's attorney clarified that the parties reached a settlement. So with trade dress, the standard is high. The plaintiff claimed her trade dress included a monochrome palette of cream, gray, and beige, minimalist modern backdrops, personal appearances in the content, and a relatable tone in the product promotion.
But IP law has not traditionally protected how someone styles something, or how they do their makeup, or how they decorate their homes. But when influencers work with brands like Amazon or other brands, they're all choosing from the same pool of products to promote. And this means that their product lists are going to overlap and they're going to describe similar items in similar ways. So if we start giving legal protection to general aesthetic elements, it would make it much harder for creators to do their jobs without constantly worrying about law. Now, before you consider legal action, make sure you're not trying to protect general trends or aesthetics. Make sure you're documenting your original creation process with timestamps. And if you think that there is a infringement claim, go talk to an attorney. Now, what do I think about this case? I agree that a lot of creators have a very similar clean girl aesthetic. That's just trends in general. But when you actually look at this evidence side by side, and I'm going to put pictures around this, the defendant was blatantly copying the plaintiff. And this wasn't just about using beige colors or minimal aesthetics. The defendant was replicating specific elements of the plaintiff's brand identity. And this allegedly started after they met and discussed collaborating. So we're talking about copying specific physical traits, presentation style, and even product styling. So why did the plaintiff drop the case? This wasn't about having a weak case. As the plaintiff said, litigation is expensive and time consuming, and she wanted to focus her energy elsewhere. I believe she said on her TikTok video that this would have costed up to $500,000, which is not a little bit of money to litigate this. So even when you have strong claims, the reality of litigation can be overwhelming, and especially if you're trying to like run a business or you have a family or other things to tend to and you don't have unlimited resources. So this tells us that even really strong claims can be difficult and expensive to prove. um, and settling may often make more sense than going to trial. With regard to content creation, there's a difference between following trends and systematic copying. The line between inspiration and replication does exist, even if it's hard to define legally. And building a truly distinctive brand is still going to be your best protection. So if you're building a content business and want to understand what's actually worth protecting legally, I have resources that help. I have the brand protector, which is a DMCA takedown notice template that I use for me and my clients to get stolen content taken down. And if you want to work with me to register your trademarks, we can also do that. Just book a consultation using the link below. And if you liked learning about this legal side of business and content creation, make sure that you subscribe. I would love to know your comments about this case. Let me know in the comments.